The next case to come before the court is State v. Jackson.
Hi, Mayor.
We're ready to proceed.
Hi, Ricky. Hi, Richie.
All right, the appellant will have 15 minutes and you may reserve up to 5. And the appellee, obviously, you have your 15 minutes.
Good morning, Judge Moore, Judge Carr, Judge Schaefer. May it please the court, I am Richard Kudici, court-appointed counsel for Travaski Jackson, and I am here today to discuss with you some very serious matters that brought me here today, because I really believe, upon review of this record, that my client did not receive a fair trial under a couple circumstances. In this particular instance, we have, and I must say, I give the trial court a great amount of credit for his patience and also very thorough approach. But without leading an impression that I am trying to set up a extraordinary fee app, I must tell you the record in this case took a long time, and if you were to look at it, it's 1,000 pages and some to go through. Partially because of the lower court's thoroughness, partially because of the confused representation. Here we have with Travaski, he wants to have a lawyer, then he wants to be pro se, then he wants to retain counsel. So it was very difficult. But there are two significant issues that I would like to address this morning relative to my persuasion that he was denied a fair trial. Here particularly, we have an instance where the government, the state of Ohio, failed to adequately provide sufficient discovery about a very critical, a very significant component of the evidence. Now in this instance, you know, the goal of discovery, as in all cases, is to prevent surprise. I mean, that's the purpose of the discovery rules. There were appropriate filings relative to requests and to obtain a proper discovery. In this instance, we had two girls, Janae Jones and Alexis Mitchell, and Janae was a friend of my client, supposedly. So Janae is a major witness here. Janae gives an accounting, but Janae is a co-defendant who gets a great deal. But in my argument number 7, we're talking about a letter that Janae writes after the deal and the plea bargain to the court regarding her demand that she gets a reduced sentence in return for her testimony. So in this written letter to the court, there are some particularized things that Janae says that demonstrates potential motive, bias for her testimony, potential to make up to whatever. The court denied that admission of that letter, and we're asserting that as there. So Janae as a major witness, so we have Janae and Alexis, and Janae gets a call from Travaski who says, hey, let's hang out tonight, hey, we're gonna pick you up. So according to Janae, Travaski and Deshawn, the co-defendant, and Alexis, the co-defendant, so you have 4 co-defendants here, get picked up in the car, and what's going to happen now is this terrible story. Janae and Alexis are going to go to where they're supposedly ordered up as girls or something. They're going to go have sex with the decedent and maybe 1 or 2 of the other guys. So Angelo is the decedent, and then his brother is Alicio. So these girls are going to go have sex with these guys. And then what's really going to happen is they're going to set up a robbery that turns into a horrific murder. Now, part and parcel of that, Janae and Angelo are the ones, they go upstairs to the bedroom and they're engaging in their behavior of sexual activity. whatever is going on there, and then Alexis and Alicia stay downstairs, but something goes on, and during the period, Janae says she is actually on her knees giving oral sex, and she sees an image in the background through bright light with a masked person that comes in the room. And this then leads into the situation where Janae claims that Deshawn shoots Alicia. So we then have Janae claiming, well, Travaski was there as well. And so we have Janae, through her unsettled testimony, and through with the failure of the letter, to give an identification. So that credibility of testimony is critical to scrutinize. Now, the big concern here, beyond the admission, the failure to admit that letter, is that Alicia has typically said in the discovery provided to the defendant, he does not know who the perpetrator is. He cannot identify the perpetrator of Travaski Jackson or the other fellow. So now at trial, all of a sudden, Alicia says, oh, you know what, I recognize Travaski's voice. We have a voice identification at trial in front of the jury, unbeknownst to the defendant. This is extraordinary when you put together the identification issue and the whole picture here.
Is the record going to indicate that your client at trial spoke at some point, and that was the time at which Alicia indicated that he recognized his voice?
Absolutely, and he bolstered that by saying they were together in Oriana House.
Which
on
the
top
trial court allowed some time for the parties to do some investigation and bring before it documentation that in fact they were together.
Well, I thought you might bring that up, Your Honor, and yes, that is absolutely true, and they scrutinized that clearly, and they went over it in sufficient time. They got some records for Oriana, so we may say, well, what was the surprise? They already knew it. Well, the surprise is they're unprepared, they're at trial, they can't deal with it, they can't get an expert, they can't test it. Those are the details that compel an abuse of discretion finding here by the trial court, in all due respect. You know, when you have the identification of as crystal clear as that as a surprise, now the state of Ohio will say, well, no, they poo-pooed it, but they acknowledge that they knew about this in fact. And if you look at State v. Roofton, as I cited in my brief, failure to provide discovery in that case, the court did dismiss the case, the charge at least.
But they knew what? The state acknowledged that they knew what?
I'm sorry?
You just said the state acknowledged that they knew it.
They knew that that Alicia had told them earlier on during their interviews that he had recognized my client's voice. And that's the component that was never revealed or discovered till the point at trial.
I thought they had acknowledged that he had indicated that he recognized a voice. But then when he heard Jackson speak, he's like, oh, that's the voice, and I remember now from Oriana House.
Judge, I have my colleagues on the prosecutor's bench, office, if they are told, I can guarantee you that they heard a voice, they are going to know exactly what that voice is. And I do believe the record demonstrates clearly, without question, that the prosecutors knew that Alicia had made a voice identification. There's just no way. My colleagues over there are very diligent. They're not going to miss that. Now,
Well, what about the fact that the attorney then, the trial counsel, didn't ask for a mistrial or didn't do anything right?
well, I think the clarity of how he approached this was tantamount to saying, well, wait a minute, we need to do this, or it's not fair, we need to exclude the testimony. I don't think, once the court ruled on it, that a mistrial, he had already made his ruling relative to admission. So I believe that's very clearly provides for an unfair trial in this particular instance, and I think that critical importance has to be dealt with here. Now, we also must look to the other topic, Your Honors, and that has to do with the notion of the failure of the court to allow certain testimony to impeach Janae. Now, the court made a finding that the testimony that Travaski wanted to provide was about activity before the murder, that the court classified as an alibi. Now, naturally, we know that the court does have discretion to allow for an alibi. In this instance, we have the failure because the court says it's a collateral attack on the testimony of the witness, and therefore, even though it may be relevant, it's not allowable to the rule. And I would ask...
Counsel, I'm going to interrupt just for a second because you're just slipped below 5 minutes.
I would like to reserve, I think I reserved,
Maybe
three minutes,
that,
was it?
Write it down.
I would
Yeah,
like to
that's fine.
reserve 3 minutes.
Thank you.
So ending now with my approach, I do ask you to scrutinize the collateral testimony, impeachment testimony theory that the court ruled upon, denying the ability of my client to provide alibi testimony, because there were 3 witnesses that I think very clearly could have given testimony that was relevant, you know, like any testimony. Well, I saw Travaski, you know, at 9 o'clock, 9:30, Travaski did this, he was doing that, we saw him at such and such a time. I don't think you need an alibi statement for that. Even so, the court abused its discretion. Your Honors, in this case, those 2 critical factors relative to identification and behavior of my client led to an unfair trial. I believe even as thorough as the judge was in bending over backwards for Travaski, I think the court lost track of some of the fairness secondary to the rulings that were made procedurally and in regard to the evidence, as I have argued in my brief here. And with that, I think Travaski is entitled to a fair trial, so that, I mean, by allowing him to explore and deal with the voice identification testimony.
Thank you.
Yes, ma'am.
Now, may it please the court, my name is Richard Cassay, representing the state of Ohio in this case. It appears that when we do not have evidence in the record, then the argument's going to be, well, I know my colleagues in the prosecutor's office, and I know what they would have done. That's an interesting approach to an appellate issue, but I don't think it's sufficient. Concerning the voice identification, the record is going to be clear that the witness, Alicio Samuel, did not tell the state prior to this trial that he recognized Travaski Jackson's voice as one of the robbers. What the record is going to show is that perhaps he mentioned, I recognized a voice, and the prosecutors did not know whether or not it was in preparation for Jackson's case or whether it was in preparation for Janae Jones's case. When this arose, the first thing that had to be done was secure documents, because Alicio claimed, I heard the voice at Oriana House. Jackson said, I was never at Oriana House with this fellow. Well, the record proved that that was wrong. He had been. Then Alicio says, I recognized Jackson's voice. I had never spoken directly to him, but at Oriana House he was known as ATL, whatever that is supposed to signify. The defense lawyer, who in my view perhaps had a better vantage point than Mr. Kudachif at this at this stage of the game, made a point of saying he did not doubt the good faith of the state. The defense lawyer, again with his, I think, superior vantage point, never asked for any sanction, a continuance, a mistrial, anything at all that would have been available to him had he thought this issue was worth more than a hill of beans. Now, we have to preface this with the facts that Mr. Jackson admitted to the police that he was part of the four-member group. He went there, he participated, and he had a gun. And he participated afterwards when they all drove to Jackson's apartment and divvied up the loot. So, not only was there no issue made of this by defense counsel, but it's not error, and if there's any error at all, it would have been completely harmless. I'm going to touch on the letter of Janae Jones because I think Mr. Kudichev did that. The letter that is at issue was written by Jones to the trial court, and in it she was complaining about her plea bargain. She pled guilty to murder and got 15 to life. She didn't think she was treated fairly. She wanted to withdraw the plea. She said nothing that was exculpatory to Mr. Jackson in that letter. The letter was in the hands of defense counsel at trial, and Jones was cross-examined with the letter. In the letter, she says that I am testifying for the victim's mother. At trial, she said, I'm here because of the victim's mother. I don't like it, but because of the mother, I'm doing it. How this is any kind of due process violation completely escapes me. And needless to say, it was not.
I was presuming that inasmuch as she was a co-defendant who was testifying against Mr. Jackson, that the court gave the appropriate instruction to the jury.
On accomplice testimony.
Yes.
Yeah, I believe it did, and if the court had not, I am sure that Mr. Kudichev in his thorough preparation would have told us about that. The trial court, as Mr. Kudichev remarked, was very solicitous to both parties and very careful. So I'm going to tell you, Your Honor, with confidence that the accomplice instruction was given.
And I raise that because it seems to me that the motive or the reason that this argument is being raised that the letter should have been admitted is to stress the fact that she had a deal that she was pleading. And so if that instruction was given, you know, what does this add?
Doesn't add anything. Of course she had a deal, and everybody knew it. The state has to disclose that, and it was disclosed. And more to the point, the letter, if there's anything you can read into the letter, is that she didn't like the deal that the state of Ohio gave her. That isn't showing bias against Travaski Jackson. If anything, it indicates hostility to the state, at most. Now the alibi. Again, the trial court required defense counsel to make a proffer, and eventually the trial court denied the alibi witnesses because they were not true alibi witnesses. Prefacing that against what I see as the underlying current in this trial, and that was Travaski Jackson's repeated attempts to defraud the court. Most glaringly, his one true alleged alibi witness, Murphy, came into court and said, I don't know anything about his whereabouts, but he wanted me to come into court and tell a different story. That's his alibi witness. He presented text messages logs to the court and the court found they had been altered. So now he wants to bring in these 2 or 3 or 4 alibi witnesses, and I have summed up the import that Jackson took Jones to the house around 9 p.m., more or less, and came back several hours later, around 11, and maybe between 1 a.m. or even later. His alibi witnesses dealt with the time of approximately 9:30 p.m. to right around 11 or 11:30, and he was out talking to people and eating waffles. Well, he may have been eating waffles, but that is not an alibi because of the time frame that we're dealing here. He dropped her off. He didn't stay. He dropped her off and left, and he came back later. What he was doing in the interim is irrelevant. That is not an alibi. And the trial court made the correct decision. There is no abuse of discretion, and that assignment has no merit. I believe that I have addressed Mr. Kudichy's points, but if there are any questions on anything, I'll be glad to answer.
I don't believe so, thank you.
Thank you.
Oh, I did have a
Sorry.
question. I'm
Go ahead.
sorry.
No, go ahead.
I have one question regarding the point that appellant made regarding whether or not he renounced his involvement or his intention to harm the victim. Would you speak to that?
Yes, termination and renunciation is an affirmative defense. There was no affirmative defense claimed at trial. Now the argument is that the court, even though it was never claimed and there was no basis for it, sua sponte should have instructed on termination and renunciation. What happened was the 2 armed males come in. One of them goes up to Angelo Kearney's room and shoots him twice. The other armed male marches Alicia Samuel up the steps with a gun to his head. They're up there, they came back down. Then the one male, who apparently is well, for purposes of this discussion, I will assume is Travaski Jackson, says, "You cooperated, I'll let you go." But his next words are to Samuel, "Lay down flat on the floor and put your hands out with your face down." Samuel says, "No." At that point, he shot in the hand and in the head. Prefacing again, the other armed male says, "I did mine, now you do yours." So it wasn't the same male who shot both. There was only 2 armed males there. And the evidence, I think, is clear that it was Deshaun Spear who killed Angelo Kearney. That leaves only 1 armed male, and that's Mr. Jackson. So he shoots Alicia. Now, the argument is that by saying you cooperated, that is a renunciation of criminal purpose. Well, no, it isn't, because he shot the guy. And then after that, the 4 drive over to Jackson's apartment and divide up the loot. So, there's no renunciation. It was never claimed at trial that there was a renunciation. There's no argument that it was plain error, and that assignment is, at best, without merit. If there are no further questions, I'll conclude.
I don't believe so, thank you.
Yes, Your Honors, indeed, I love that theory. It's theory. Well, Travaski must have killed him. I mean, we did the shooting because, he said, "No, I did mine, I did yours." The state doesn't know who did any shooting here. There is no way for them to demonstrate that. And the point of renunciation theory is that the clarity of the language that was quoted by Alicia said, "I'm going to let you go." Now, if you divide up the loot, that in and of itself does not provide for failure of renunciation. Now, back to the voice ID. I ask you to look at the transcript at page 633 when you get a chance. The prosecutor said he mentioned that fact to us. He talked about trial and testimony and coming up and asked him what had happened. He mentioned that fact to us, that he recognized the voice from Oriana House. And you're here to tell me that my learned colleague is not going to ask him, oh, what voice? Then he goes on to say, we never did anything further. It's preposterous for me to assume from this record any lawyer is not going to explore that. The credibility of Janae is extremely important here. And so the nature of how the description from her testimony juxtaposes into the testimony of Alicia relative to the voice administration, voice identification is critical. If you talk about, and looking through that whole transcript area there, you'll see some more conversation about that. When you talk about acknowledge the failure to be able to cross-examine on that letter. As Mr. Casey says, there are a number of topics that would be involved in that letter.
Is it, this troubled me when I was thinking about this. Everyone keeps referring to it as a letter, but then you both say that she wanted to withdraw her plea. Was it a motion that was filed to withdraw her plea?
You know, Judge, the thing about the letter is it goes to the ability, the reason that you couldn't attend, the defendant couldn't attend to that letter is because it wasn't there to cross-examine. Whatever the conversation may be between Janae and Mr. Gallick remains to be seen, or would have. You know, I would have gotten up there, Janae, wait a minute, what's this letter all about here? Oh, you got the plea, and then you're going to talk about the plea deal. That's of critical importance. The plea deal in this instance would have been able to be better defined and credited through that letter. Now, finally, in regard to that alibi, what is the problem with giving testimony about what was going on for the defendant to paint the picture? To deny that testimony and to deny, finally, my client's right to go back and testify, that is, to reopen the defense case. These all led to the big picture of a denial of fair trial. And I ask this court to scrutinize that. It's a difficult, really, transcript to follow. I mean, just because it's so convoluted, but I think the thread is there that demonstrates just so much going on.
Thank you.
Thank you.
Counsel. The court will take the matter under advisement and a written opinion will be sent to both sides. And you can also check the Supreme Court website and our website. Thank you, John.
Yes, Your Honor. Thank you.